949.
949.
9495.
Okay, real good then. Now,
Oh, good. What happened, Bill?
well, we went down to see the attorneys,
Yes.
and we spent 2 full days there. Peggy was there and everybody,
Yeah, Wednesday and Thursday.
Yeah, and then we just talked, and the lawyer says, well, it's a tough case. He says the whole thing of it is, he says that I'm greatly shocked myself because now I understand the whole thing, So he says that, what it boils down to is they're charging you for this, for like trying to defraud people, But he says you haven't defrauded anybody,
That's right. They have to prove their case.
Yeah, and then he says that they're charging you with money laundering, and the only thing that you did is you put your own money in the account, and then took the money and paid it out, But he says that's your money, nobody else's,
Yeah.
In other words, you didn't get any money from drugs or nothing from money laundering,
No.
So the only thing is, he says that when you put a check into like a trust account or something like that, he says the check came from another trust, but he says, really, what harm does it do? He says that, I guess if you wanted to dot every I and cross every T, then you should have maybe have put it into a separate account,
Uh-huh.
But he says, even at that, he says, who the hell have you hurt? Nobody, really.
That's right.
So he says the whole thing is absolutely ridiculous,
Yeah, oh, good.
So, but he said the only problem is now, he says it's, you got to sit there before a whole bunch of jurors, and he says you got to, in the back of your mind, that they'll come in and they're sitting there, and first thing a lot of them think about is you must be guilty because you wouldn't be there otherwise, and then they got to sit there with an open mind, and then when they finish portraying you, living in this huge home, and driving brand new cars and, all this and that, they're going to portray you as being, a rich guy that doesn't want to pay no taxes or nothing, and that a lot of the jurors might be poor people, which most of them are, and they're going to sit there and be very jealous, and so he says, they got to decide, but a lot of times you don't get a decision based on old facts, So he says you don't know. He says it's kind of difficult. He says when you're going in against money laundering and stuff from the government,
But you didn't do it.
I know, but they twist things and turn things, and they say,
Oh, they lie like crazy.
oh yeah, and they'll do. The problem is that the government is doing anything that they can to win. In other words,
Oh, sure.
they don't say, well, here's the fact, we just...
Oh, no, they play dirty.
Yeah, so
They can't play squarely and fairly.
right, they say we got to submit all these derogatory things, and we don't want to submit anything that's good for them,
Well, they by law, they have to.
Well, they're supposed to, but it's like one thing that we discovered from their files, which they didn't give us, was tucked in with another set of papers, which they didn't realize was in there, I guess, because they did a complete financial search on our background and everything, and you know what it says?
What?
It says that both Celeste and Bill they pay everybody, and they're paying very promptly, and they have no creditors,
Oh, yeah.
for 40 years.
Oh, boy.
40 years.
So your lawyer will bring that out of them?
Well, yeah, he'll bring that out, but it's like,
Isn't that a wonderful record?
well, it's a wonderful record because, both Celeste and I are extremely Christian, and we believe God's paying everybody,
Yeah.
So it doesn't matter who we owe, or a lot of people cheat us, but they still get money, And a lot of these lawyers have cheated us right along, but they all got money, But the only thing is, like he says, by the time they twist things around and everything, you really don't know going in there what they're going to decide. You're at their mercy.
Well, right.
He says, like, he sat on he was a judge, on the Supreme Court of Tennessee.
Oh.
This lawyer, one of them.
Oh.
So he sat there as a judge, for the Supreme Court there, so he's heard all kinds of cases,
Yeah, does he know Smith?
Smith?
what's her name?
Jennifer?
No, what's her name begins with G? Gibson. Does he know Gibson?
Oh, yeah, he's been before her.
Well, then, do they get along?
Yeah.
Well, maybe that'll have some help.
Well, it might, but like he says, you know, he was a prosecutor too for like 20 years. Besides that, you know, and you know, he sees the whole facts of this case, you know, and he says, "Wow," he says, "you know, there just isn't any criminal intent here."
No, they have to prove their case.
Yeah, he says that's true. They have to prove their case, but you know, you're dealing with 12 people sitting there that are all. Probably a good portion of over half of them are black, and they're probably very poor, you know, and they got their mind, you know what I mean?
Well, then you know, you're not supposed to do that in a trial. That's against the prosecutorial code.
You hold on 1 second.
Yep. That's against the prosecutorial trial, and if they do that, then you can say you did not get a fair trial.
Well, you know, Glendora, you know as well as I do what that means. Absolutely nothing in their eyes.
Well, it means something in the appellate.
But we just got 2 more decisions down from the Sixth Circuit appellate, you know,
Yes.
on cases, you know.
Yes.
One of them was for the habeas corpus for Celeste, you know, so that she could get her operation.
Yes.
And they said that, well, they agree with the lower court, and it is kind of along the lines of frivolous, you know.
Oh,
And,
gee.
and then they say, you know, because we questioned who even heard it in the district court because the ruling is the complete opposite of what it should be. And then it also said that we doubted that a district court judge, being a district, I mean a 3 judge, you know.
Yes.
Would-
3 judge,
Yeah, would probably never write something this bad, you know.
Yeah.
To that effect, you know. And then they said the second thing that they addressed was the who wrote the decision, you know, if it was a court clerk or what, you know.
Yes.
And they said that this court is not even gonna, they don't even think it's worth answering, so they didn't say that.
Oh, that's terrible.
So that was one, and then the other one, Peggy, and you know, wrote up for an appeal, and that thing was thrown out because they said that the district court had some pretty good grounds, and they didn't see any reason.
Oh, that's terrible. Collusion.
Oh, this is like maybe 9 or 10 appeals now, and every one of them you get nowhere. It doesn't matter what you say, what you do.
That's in Cincinnati. That's in Cincinnati.
Yep,
Isn't that awful?
sure it is. Sure it is. But there's absolutely nowhere you can go now. That's the end of the line.
Yes.
So you can't go anywhere. So when I see these things happening, Glendora, you know, 9 or 10 times out of 9 or 10 times, however many it's been, every one gets shot down, so you lose all faith in any appeals that you're going to go under, you know.
Yes, right. You've still got to go to the Supreme Court, though, as a matter of form.
Well, yeah, but
Oh, you still got to.
I know, but there's, what, 1% that gets heard?
Less than 1%, yes.
Less than 1%.
Yes, but you got to go.
Well, I know you gotta apply, but that means nothing, you know.
I know, it means nothing, but you've got to do it, so they can't say you didn't do it.
I know that, but I mean, if you got less than 1%, I mean, if we were discriminating on, or if we were a black organization, or you know, we were Gates or somebody like that, then maybe the Supreme Court would even read it, you know.
Yeah. Oh, yeah, it's a big farce.
A couple down from 10.
Oh, yeah.
You know, hell.
We definitely need a Supreme Court. What we got is zilch.
Yeah, right. We don't have anything. Actually, they should have a Supreme Court, but maybe they should have, I don't know, different courts or something where they hear more cases, you know, because they just take whatever they want, and then they go on a 3-month vacation, and, you know, just take little things here and there, really, you know.
You're right. I asked the minister this morning to pray for you.
Well, that's very kind of you to do that, you know.
So we still have that.
Well, we got, like I say, both Celeste and I, you know, pray every day, you know, and we naturally ask them to stop these unchristian people, you know.
Yes.
But the thing is, well, that's all we can do is pray, you know. I don't know what he'll decide to do or how he's going to handle it or anything. None of us do, you know.
Did you start making a record?
Oh, yeah, I've been trying to write things down, you know, constantly.
Oh, good.
Yeah.
Oh, good, Bill.
Yeah.
do you audio tape it or write it?
No, I've been writing now.
Yeah, that's good.
I can change it later or write and read it later, you know.
Oh, God bless you. Well,
but I don't know what to do. I mean, every time I talk to the attorney and he's explaining everything to me, you know, and the way it should be, but the way it is, it's entirely different, you know.
Oh, it's terrible. Isn't that an awful thing to happen in America?
So he says that, you know, you just don't know. He says you could go into before a jury on a slam dunk thing and lose, you know. He says it happens all the time, you know.
Mm-hmm.
You're at their mercy, and they don't know the law. They don't know nothing, you know.
No. And they're twisted around by the judge, which they shouldn't be. But listen very carefully when the judge charges the jury, because you can very carefully get a thing overturned if the judge charges the jury wrong.
Well, you figure, you know, naturally they're going to do that because we'll have a transcript, you know, so every word will come out.
Yeah, but watch that, because that is a way out.
Yeah.
The way the judge charges the jury.
Yeah.
And the judge will be very nervous, let me tell you. The judge will be very nervous.
I don't know. She's been sitting there for 20 years.
Well, it doesn't make any difference.
Yeah.
They get so nervous, those judges, when they charge a jury. You never see anything like it.
Yeah.
I was in a judge's chambers about 2 months ago, and I know the clerk very well, and we were chit-chatting. And I know the judge very well.
Yeah.
And he came back from lunch, and she says, "You have company." And as long as this judge has known me and liked me, he says, "Oh, I can't do a thing now. I can't do a thing." He gets on his robe and he rushes into the courtroom. And then Nancy said to me, the clerk said to me, she says, every judge is like that when they go to charge a jury.
Well, I hate to base anything on that, you know, but it's like he said, you know, when from the first minute you go into the courtroom and they get up before the jury, they say the United States of America.
Oh, that's what they do. But what they are, really, is the anti-United States of America. They're not the real United States of America. They're the anti-USA.
Well, you and I know that very well, you know.
Yeah, well, that's what we're trying to teach the public.
And that's what we're trying to teach the public. But sometimes, you know, it's like talking to a brick wall with a lot of these people, you know. The United States of America scares the hell out of everybody, you know.
Oh, well, I don't think anymore.
Well, a lot of the older timers probably, you know, like you or I aren't scared, you know.
Well, the people who watch my program aren't scared either.
Well, maybe.
They know the truth.
A lot of people know the truth and they agree with you, but when it comes down to them, they're like a scared dog with a tail between their legs, you know. They're scared, you know.
Yeah, well, that's true, but I don't think it's quite that bleak, okay?
Yeah.
I think we are making progress.
Well, I'm sure we're making progress because a lot of articles are coming out about this and that.
Yeah.
A lot more.
Michael Brown sent me the McCullough article. You don't have to.
Oh, good.
And I'll be reading that on TV this afternoon, I hope.
Oh, good. That would be good.
Okay.
Boy, did you read that and see what that said, you know?
Yeah, well, no, I'm going to, though, when I read it on the TV.
And that's only just the tip of the iceberg.
Yeah.
That goes back for years and years and years, you know?
Yes.
About these attorneys and everything. He took one of them by the ear, you know?
Yes, I know.
Got right a hold of his ear and dragged him into his, and he took the other one by his coat. Just grabbed right a hold of him and yanked him right in his chambers, you know?
Unbelievable in America.
And then of all people, the U.S. attorneys, you know, there was like 5 or 6 of them in his courtroom, you know, that had different cases. And he called them all idiots and didn't know what they're doing, threw every one of them right out of his courtroom and says, don't come back, you know.
Yeah, that's good. He's right. Now, you don't want any of this on TV in Memphis?
Well, you could put all McCalla and all that stuff on, sure.
Mm-hmm.
But
Okay.
that's all public notice, you know. It's out of the newspaper.
Okay.
Yeah, that's there, sure.
Okay.
And it's only the tip of the iceberg. Like that whole article attacks all of Memphis.
What about the bulldog?
Bulldog.
Your dog?
Oh, how is he?
Yeah.
Yeah, he's all right. You know.
He's all right?
Yeah, he's all right.
All right.
You know, naturally, when I'm gone I had to be gone for 4 days, you know.
Yeah, did you hear my message that I called you 15 minutes after you checked out? I really messed that up.
Yeah.
And the other time I called you, you weren't in either.
I called you the minute I guess you got the message, though, didn't you?
No, I didn't.
Oh, I called you.
Oh, yes, I got a message. message right away.
Oh, okay.
And then, that's right, and I called you twice, but I mistimed it.
Yeah, I know. The first time I got that message from the hotel, and of course,
Okay, how is the business?
oh, boy, the business is going like crazy, and then,
Were you able to make up for what you missed?
well, no, you're going to lose thousands of dollars, you know.
No, it's terrible.
You want to hear something else, which was horrible, was when I get back, you know, I took all the checks, you know, that I have from the business, you know.
Yes.
I went to put them in the bank, and the bank had a big notice on the thing, do not accept any more deposits or...
Why?
Well, we don't know yet. When I went to the bank, I went to a branch, which I deal with, you know.
Uh-huh.
And then they just told me, well, you're going to have to go down to the main office, to the accounting down there, you know.
Well, that's crazy.
So I got in my car and went right down there, you know.
Yeah.
Naturally, I get there 10 minutes too late, and the doors are all locked and everything else, so I don't know.
Oh, now you got to wait it out until Monday.
Yeah, so I don't know if it was the government or the Internal Revenue or hell, who knows, you know.
Oh, God, what a worry.
I know, one thing after another.
Oh, that scares you.
So I don't know, that almost indirectly puts you out of business there too, you know. So I don't know what the hell could happen next, Glendora. You know, it's one thing right after the other, you know.
Oh, God. On Esther Gutman, Victoria Gutman took her daughter to an evaluation service, and they wrote out a detailed report, and it is quite convincing, and that's about 5 or 6 pages long. And then there's another document in support that is 5 pages long. Now here's what I have told Victoria Gutman, that I will make this videotape for her, this first half hour, and I would like to see her buy a tripod and a video camera and a microphone, and hook it up to a TV set and sit down in front of the camera and tell you her story. In public access, if Dr. Gutman, the PhD mathematics professor, wants to tell his story, then he can do it on public access. In television broadcast, there's the equal time requirement. In cable public access, there is not. Equal time is handed by the fact that anybody can communicate with his neighbors. So that's where he will get his chance to say his side of it. And I would like Victoria Gutman to take this tape and the others that she has made and go to Cox Communications and see the public access director and fill out all their forms and hand in the forms, send a copy of the forms to me, and hand in the videotape. Both this one that is made as a chat with Glendora, and also her videotapes that she will make to complete the story. The public has to know. She has a First Amendment right to tell the public, you, the all-important public. In addition to that, you, the all-important public, you have a First Amendment right to know. So it cannot be kept from you. This is America, the United States of America. This program will be played in New York, the state of New York, the city of New York, Queens, Bronx, Brooklyn, Staten, and Manhattan. It will be played all in the county of Westchester on those cable systems and all of the cablevision systems in Long Island. It will be played across the Hudson River in Rockland County. It will probably be played in Santa Fe and Los Alamos, New Mexico, and it may be played in Buffalo, New York. But the point is very clear. All over the country, you have judges and lawyers violating citizens' rights. And we are here to watch them, report them, picket against them, sue them. We are here to stop it. This is Glendora, a chat with Glendora on the autumnal equinox, September 22nd, in the year 2001, Anno Domini.
who are you? Because she had the the recorder and her microphone she was setting up at the panel, because when you go up on appeal, if you have an oral argument, it's usually a 3-judge panel that's sitting up there that you have to address your argument to. And so she was setting up her microphones, and this clerk came running out, and he said, "What are you doing here?" And she said, "Well, I'm just setting up the microphones because I'm the court reporter." He said, "Oh, no, that's not allowed here." So I got up and went over to him. The judge wasn't in the courtroom yet. And I said, "No, we have an order, we have approval to bring her in here." "Oh, this is not going on in my courtroom. This is a clerk. This isn't even a judge. This is not going on in my courtroom." So I said, "Wait a minute. And this is, you really have to know when to be firm, okay?" And I said to him, "Now wait a minute. That's not your decision to make. I have an order. The judge said this is what's going to happen." He said, "Well, I'm going to go back and talk to the panel. Here's the threat. Oh, I'm going to go talk to the panel, and they're going to really be mad at you. You're going to lose the oral argument, you know." I said, "Okay, fine. We'll wait." So he went back, and 15 minutes, 20 minutes, and the judge isn't coming out, and he's not coming out, and he came out, and he said to her, "All right, go ahead, set it up." This guy, and then he looked at the attorneys on the other side, and there were 2 of them, and he just went, because I guess he was going to have to give the money back, I don't know. But anyhow, we got our court reporter in there, we got the transcript, and the reason it's important, and it is very important, we were on appeal in one of the cases in West Palm Beach, and when I got up to argue my side of the case for my husband and I, 2 of the judges out of the 3-judge panel at different times during the argument stopped and said, the first judge said way in the beginning, he said, "I don't usually ask pro se litigants questions, but I can see that you really understand what you're doing, and I'm very impressed." And then about 10 minutes later, one of the other judges made a similar statement. I got to tell you folks, honest to God's truth, I've got the tape home. Both of those remarks were erased from the tape that was made by the court reporter, so that I couldn't go back in and use it in another case where the attorneys are saying, "Oh, these people are crazy, they're nuts, they're, you know," and it's off the record. But when you hire a court reporter and she comes in and she's working for you, and most of these ERCs are really honest people there, because they're trying to make the stenography area of this a little bit different. The stenographers are making very big bucks out there. I mean, you're talking $3.75 a page to get it printed into a transcript in our area. Some areas it's higher, some areas it's a little bit lower. That's a lot of money. The ERCs, most of them charge half of that on a page rate. So not only are you getting an absolute accurate record, you're getting what's called a verbatim record. And I've had judges say to these ERCs, "Well, they can't use you in my courtroom because we need a verbatim record." Well, that's a joke. The only way you're going to get a verbatim record is with a tape recorder. And this is the 20th century. I mean, you're not going to get it with that girl typing there. She's not a machine. All you're going to get is what she catches and what she misses because she's thinking about what she's going to make for dinner or what she's going to do after work. It's gone. And a lot of times those records are just, attorneys go crazy. They pick up the transcripts and they say, "But I know I said this," and it's not there. So you're much better off to have, if you can, a reporter with you who records by that type of device. Yes?
Well, this is just to follow up on his question about the older Black's laws. I've got all 6. And you will find as you go through them that there are words that are actually missing in some of the newer editions, so that when you're trying to deal with certain things, it is helpful to go back a little bit. But you also have to remember that the judge is the one that's going to decide what the definition means, so that if you're using those older law books, make sure you define it from the book and tell where it came from.
Oh, yeah, absolutely.
And it will be helpful if you remember that. And there's also, you'll find changes in the meanings also, and that's due to the change in the English language. Okay?
Okay,
so that takes care of your question.
Thanks a lot.
You're welcome.
We appreciate that. And one of the other things he's talking about, make sure that you say where the definition came from. When I first started out, and Michael and I, we would go into court, it's very hard to make sure that you get in everything that you want to say at a hearing because you're nervous, The judge is there. It's just a real nerve-wracking, tense type of situation in the beginning. And one thing that I do that I learned from Michael Brown is that when I do motion papers, and you'll see this in Ways and Means, the book that you got as part of your course materials. You write your motion, you make it a page or a page and a half, as short as possible, to the court. This is what I want, A, B, C, and D. And then if you have a whole big explanation that absolutely has to go in there, you add 2 documents. An affidavit that makes your statement of facts, that's signed under oath, so that to back up your position. Okay, it has to be something that has to do with the motion that you're writing. And then you do a separate memorandum of law. What that means is you're going to cite for the judge all the cases that support your position. This way, if you go into the courtroom and you draw a blank, the paper that has the motion on it is your script. You just check off as you hit each point, just like you saw Marcia Clark do when she got up in O.J. Simpson, you know, okay, that's done. That's important. You've got to know what has to be covered. You have to get it in there, okay? And then the memorandum of law has all of the case law with the quotes in it, okay? So that you're saying, this case says that because this agency did this, it denied me my due process rights. This is the name of the case. It's from the Southern Reporter or whatever volume it's from. And that way, not only do you have it, if you forget to say something, it's in the court file. It's part of the record so that it will be there for you on appeal. No one can say that you didn't say it. And hopefully you'll also have a court reporter there who is recording everything that you're saying. So you've got 3 documents that when I file a motion, when Michael and I file one, they always go in with 3 documents. It's never, because you need to organize and simplify, because that judge, all he's going to really look at is the motion. And then when the attorney on the other side gets up and starts creating confusion, you can rein him back in by saying, well, wait a minute. We're not talking about that today. We had a hearing that I'll tell you about in a few minutes just a few weeks ago, and an attorney that we've been fighting, he was one of the builders' attorneys from way back when in 1991, and we finally got him on the Fair Debt Collections Act because he took $56,000 of a bond that we had posted in the court and literally stole it out of the court. And so we have him in federal court on that. And we had a hearing where he was trying to get this other case. We were trying to get papers on discovery in another case, and this lawyer came in and said, for 20 minutes, the Daddicks have filed this case and that case, and they did this and they did that, and she's crazy and he's crazy, and you know, everything he could possibly. And after he railed on and on for 30 minutes, I just looked at the judge and I said, I don't really have anything to say about what he just said because it has nothing to do with why we're here. And you know what the judge said? He said, Mrs. Daddick, you're right. You, sir, have to produce those documents to them. And he does. And he was ordered to, and he still hasn't produced them. They should be coming in this week. But if he doesn't, we'll be getting sanctions against him and the builder. And we are now exposing all of that fraud that occurred way back there in 1991. The point, it's a very difficult thing. Okay, you had a question?
I'd just like to share what I've been learning from you all this weekend about the rules of evidence. And I had put in an affidavit at the state level in Virginia, and I found out that they're no good at the state level, so maybe in different states you have to go to the rules of evidence or something.
That's right. It's very important.
Federal, I understand they're okay. But state level, in Virginia at least, they're no good, and so my whole thing got thrown out because of that. You know, it's just something that they could do.
Okay, whenever you're doing anything in a state court, you have to check your local state rules, your local state statutes. You have to know what the law says. Now, I don't know why they would have knocked out an affidavit, because that's highly unusual, but a good idea when you're doing things as a pro se litigant, we've found, because you see, you have to understand something. The lawyers are all, and I'm sure any of you who have been involved in any kind of law seminars understand this, that the attorneys are officers of the court. Okay, that puts them one step ahead of you. when you're there saying one thing and the attorney on the other side is saying something completely different, and it's an issue of fact, most judges are going to say, well, you know, this is a pro se litigant and she's probably confused. It's not that the attorney's lying, but she's probably not, she doesn't know what she's talking about. So he's going to ignore what you have to say and listen to the attorney. This is something you've got to get around. You've got to make this judge understand that you do know what you're doing. And one of the easiest ways to do it is every paper you file as a verified document. In other words, when you file a motion to dismiss or a motion to compel, you make it a verified motion to compel or a verified answer to the motion that the other party has served against you. Let's say you sue somebody, they put in a motion to dismiss. Now you're going to answer that motion. You're going to come back, they say, your case should be dismissed for this reason, this reason, and this reason. You come back and say, no, my case shouldn't be dismissed because this reason doesn't hold and this reason doesn't hold, plus this reason and this reason. Well, when you come back and file that answer, right on the title you say, verified objection to motion to dismiss, and then you have a closing paragraph that says, I verify that all statements herein are completely true and accurate under penalty of perjury. You're going to be very surprised at how differently a judge will look at you. Now you're not that crazy person coming in there saying, I'm not going to take an oath. You're the person coming in there and saying, and you can do this. You know, if you see that there's an issue of credibility, you can go into the courtroom and say, Your Honor, before I even start, I would like to voluntarily take an oath because I really would like this court to know that everything I'm saying is true. It makes a difference. It really makes a difference.
Peggy, I just thought that it was so important when I heard it that you should bring out the copies and originals like happened to you not long ago on the deposition.
Oh, yeah, okay. This is something going back to, oh, I'm sorry. Going back to lawyers' tricks, okay? When you do something, when you're looking for documents and the other side has to produce documents to you, I don't care if it's a mortgage, I don't care if it's a contract, if it's copies of receipts, if it's copies of cash checks to support a mechanic's lien, whatever it might be that you're looking for, you have the right to insist on seeing an original document. And let me tell you something, if you're winning against lawyers, you better make sure it's the original document and you take the copy that they're giving you for your records in one hand and the original on the other side, and you compare them line by line to make sure that there's no changes. Folks, attorneys are not beyond giving you documents that have been altered. We had in that mechanic's lien case that we're still in the courts fighting about, when we asked for copies of checks, and none of our lawyers would ask for this. And when we got in there, we said, all right, we want to see all of the original cash checks that show that the subcontractors were paid. And we couldn't get them. And we, in fact, to this day, we still have not gotten most of them. But we got some of them. We got 9 of the checks. And out of 9 of the original checks that we were able to actually see the originals on in the bank after jumping through about 25 hearings to get permission, 9 of them had been altered. They were checks that had not cleared the bank, that had been given to the court as evidence that these subcontractors had been paid. And you're talking about 2 attorneys, one from a law firm and one that was representing the attorney in the construction company. I'm sorry, the construction company and the builder. They'll do it. So you have to be very careful. You really have to be on your guard. You're not dealing with honest people. You're not dealing with people that are upfront. You've got to change your way of thinking and try to think like the sneakiest person in the world to try to figure out what they're doing on the other side, because boy, I'll tell you, they just keep coming up with new ones. Okay. Does anybody have any questions? Because I'm going to be winding it up. And
I was a witness to the case for my midwife. I was a witness for my midwife when the AMA was going after her. They produced, and the problem is, we had never signed a birth certificate in the hospital. They printed my name where it said mother's signature. They produced it in court. For some reason, I don't know why, but then when I wanted to go get that copy of the document, I called the state's attorney, who was the plaintiff. They didn't want to talk to me. I went through him. I went through his secretary. They wouldn't talk to me. They said they don't know. They don't have such a document. I called the recorder. I called the clerk court. I asked for the copy of the document that was used in that case. I asked for the transcripts. They wanted $200 for the transcripts of the court.
Right.
I was trying to find the document that could help us.
Okay,
But
this is a birth certificate.
This is a birth certificate. No one says there's no such thing as a birth certificate document. They just do it all on computers now. And I said, well, there was one produced in the case.
Okay, what you have to start doing is making your requests in writing.
Okay.
Okay, and give them a specific date on when you want that document back. In other words, the attorney that produced it in court would be the first one that I would go to. And I would write a letter saying, you know, this is allegedly a copy of the birth certificate for my child, and I need a copy of it, and I've been unable to obtain it from wherever you've gone to, and I need it by such and such a date. Give them 10 days or something, and I'll be glad to pick it up in your offices. And then if they don't, then you pick up the phone and you say, no, wait a minute, you know, is there a problem here? Because you have a right to that information, or they're producing something that just, I mean, where did it come from? It had to come from someplace. It has to be on file somewhere.
I called the state of South Dakota, and I said, how did they get a hold of it? And he said, there's no document that exists. Everyone kept denying that there's a document that existed. I said, well, it was in court.
And did you go to the clerk's office in the county
Yeah, I went to the
courthouse?
clerk's office.
And there's nothing on file there?
They have nothing in file. And when I asked for the exhibit from the file they showed me, it wasn't there.
Oh, yeah, I would talk to me about that later.
Ladies, I hate to break this up.
Oh, well, Peter.
I go upstairs for 20 minutes, and the whip stops being fed. All of this, are we still on? Oh, well, you are.
Can we help you, sir?
Is this? The lady's question was, and I quote, "Can we help you, sir?" And if my lovely and vivacious and multi-talented wife, the love of my wife, the wife of my youth, and the mother of my daughters, if she were here, she would explain to you without blushing that I am, as you have suspected all along, totally beyond help. That being said, our dilemma is we have the constraints of audio tape. Now, a lot of this is going to be on the video. We're still running video, but the audio tape is long since expired, and our ambassador, Robert Fox, is laying prone in between his equipment tables, trying to figure out how to rescue all of this information from the memory hole. That being said, this is a B-side that we just finished, Robert? Well, this is a 15-minute set break, and we are going to take a short break, and we hope you do too. And thank you.
Thank you.
or cliquish or clannish anyhow, and certain groups work better together. The objective is to get as much experience.
Now comes the fun part. The great thing about being the rainmaker at Erwin Rommel School of Law is I get to stand in a courthouse of ideas. In one corner of the courthouse is Mr. Connect the Dots himself, our Field Marshal, Michael H. Brown. And in the other corner of the courtroom is our next speaker. Mr. Rogers essentially presents the spiritual side of the law. And to give you an idea of how it is that Dwayne works, listen to me. I think I've been here for 2 days doing this. There's a war story, legendary or true, in the Patriot movement from about 12 years ago. A woman in Indianapolis, Indiana, was diagnosed with terminal cancer. And she stumbled into a health food store looking for an alternative and struck up a conversation with the clerk, who directed her to Bernard Jensen's book, Tissue Cleansing Through Bowel Management, which led her to purchase a colonic irrigator. And to make a short story very, very long, 11 years later, people from 10 states were coming to this woman's house in a subdivision in Indianapolis, Indiana, to be cured of cancer. And ultimately, as you might expect, and when she opened the door, the Blues Brothers were standing there with pistols. And they placed her under arrest, and the charge was the unauthorized practice of medicine. And she came to one of our early mentors, Dwayne and my early mentors. He had a teaching class, a 5-day class for people with legal problems. And when she explained her problem to our mentor, he said, "Lady, you belong in jail." And she said, "I paid good money to hear this." And he said, "Ma'am, your problem is cancer is the copyrighted trademark of the American Medical Association. Do you have a license from the AMA to practice medicine?" And as her eyes started to open, he said, "I don't know what you're going to do, and I don't know what you should do. But if I were you, I would immediately cease and desist treating cancer. And I would start treating consumption and the burning ague like Moses taught you in the book of Deuteronomy." Now, there are 4 commissions in the New Testament. And they are heal the sick, cast out devils, buy a sword, and preach the gospel. And when you treat and cure consumption and the burning ague, you are healing the sick. He discussed a couple of other unusual techniques, and when she made her first court appearance, she was dressed like a Mennonite lady, except for the skull cap, and her daughter was dressed accordingly. And they wandered through this court proceeding, And at every turn, she raised a religious objection. She changed the question. And finally, the judge looked down over his glasses and said, "Pardon me, ma'am, do you own a colonic irrigator?" She said, "Why, yes." And the court said, "Have it in here tomorrow morning at 10 o'clock, recess." 10 o'clock the next morning, she sat at the table with her daughter, and the judge came out and started the proceeding and made sure everything was on the up and up. And he said, "Excuse me, ma'am, did I order you to bring your colonic irrigator to this courtroom?" "Yes, sir." "Where is it?" "Oh, it's out in the hall." "Go get it." And they wheeled it in through the courtroom. This is old Indiana courthouse. You ever notice how the courthouses are just like Catholic churches? There's a communion rail, and there's the high priest up on the altar, and you have to have the altar boy or the priest intercessor to deal with the guy. Okay, you got the priest. So anyway, she and her daughter, and they had gone through the lawyer thing, and she said, I can't hire a lawyer because, why can't you hire a lawyer, ma'am? Because Jesus told me not to. And this judge was old enough and smart enough to have sidestepped that and thought he could slam dunk her later. And they wheeled the irrigator inside the bar of justice, and the judge stood up and said, "Take the cover off." And as her daughter grabs on a four-wheel table, 4 wheels on 4 legs, as the daughter grabbed the wheel, the table legs, and cranked this thing, Mom grabbed the bedspread and just pulled it off. And the courtroom angel was with these 2 women this day. And this colonic irrigator did a perfect 360-degree turn. On each side of this irrigator was the same bumper sticker. Now, you understand, the day before, this woman said, "Excuse me, I don't treat cancer. I treat consumption and the burning ague." Well, these people testified to the fact that you treat cancer. Well, they probably testified to the fact that I'm a Republican. They're wrong about that too. And then it was bring the irrigator in. So the judge stands up, and on each side of this colonic irrigator was the same bumper sticker. The bumper sticker said, "Jesus saves." And this judge picked up the gavel and said, "Dismissed." And he was in his chamber like Harry Houdini. Now, legendary or true, it is said that this prosecutor scrambled in and probably said, "Your Honor, our brethren in the medical union invade upon us in the legal union to shut this babe down because she's in our brethren's lunch bucket. She cures cancer for 5% of what our brethren treat or control cancer for." And probably what happened is this old circuit court judge in Indiana looked up and said, "Mr. Prosecutor, if you think I'm going to become a footnote in the Harvard Law Review because you're too stupid to see what's coming, what you need is another judge. If you think I am going to preside over a transcript that allows this woman to stuff the first Article Free Exercise Clause of the United States Constitution down your throat until it comes out your posterior, you are living in a dream world." The case is dismissed, and Mr. Prosecutor, when you close the door, don't let it hit you in the butt. To this day, you can find this woman in the suburbs of Indianapolis, and she does not treat cancer. She treats consumption and the burning ague because Jesus told her to. What Mr. Rogers teaches is what I define as the false witness defense. What you will hear in terms of trial preparation, interrogatories, depositions, discovery, and things clunking on the podium is Exodus 20:16 in your face. Thou shalt not bear false witness. You want a quickie on how it works? Mr. Rogers is a trustee for a trust. Posterior, you are living in a dream world. The case is dismissed, and Mr. Prosecutor, when you close the door, don't let it hit you in the butt. To this day, you can find this woman in the suburbs of Indianapolis, and she does not treat cancer. She treats consumption and the burning ague because Jesus told her to. What Mr. Rogers teaches is what I define as the false witness defense. What you will hear in terms of trial preparation, interrogatories, depositions, discovery, and things clunking on the podium is Exodus 20:16 in your face. Thou shalt not bear false witness. You want a quickie on how it works? Mr. Rogers is a trustee for a trust. The grantor is charged with federal criminal conspiracy to defraud the United States government of revenue. They entice him up to the witness box. He turns around. The bailiff walks up with a Bible and says, "Put your left hand on the Bible, raise your right hand, repeat after me." He looked up at the judge and said, "Absolutely not." And the judge cranked his head 90 degrees and said, "Will you affirm?" And he said, "Absolutely not." And the judge turned his chair 90 degrees and looked down over his glasses and said, "Will you testify under the pains and penalties of perjury?" Now today, based on his studies, he would have said absolutely not. Back then, he said, "I'll do that." And the judge, waving the bailiff away, said, "Sit down." The transcript reads as follows. Prosecutor, what's your name? Response, no, that's incorrect. Prosecutor, I said, what's your name? And turning his head 90 degrees to his right, he said, objection, Your Honor, asked and answered. In our book, Making and Meeting Objections, there are 33 admissible objections, in American jurisprudence. The fourth one is asked and answered. The transcript reads, "The court. The court needs to know your name." Response, "That's nice." And to show you Christian women what you are going to face in these corrupt whorehouses with these guys in these 2,000-year-old Babylonian Halloween costumes, these long black things, this is what you're going to face. This judge looked at Dwayne and said, "If you don't tell this court your name right now, I'm going to throw your ass in jail." The response was, "My mother calls me son." As the prosecutor arose to object, locked eyeball to eyeball with Dwayne, without looking at the prosecutor, he held his hand up like a traffic cop. And the transcript reads, "Sit down and move along, Mr. Prosecutor. The objection is sustained, asked and answered." He testified for over 2.5 hours in a federal criminal conspiracy to deprive the United States government of tax revenue hearing, and they didn't know who he was. From Grove City, Minnesota, someone who knows something, Arthur Dwayne Rogers.
You have no idea how honored I am to be here. I should be in jail. In any event, with Peter John, anything's possible, so he could have me in jail at this rate. But in any event, normally what I do is research areas that most people are, what would you say, the least acquainted with, and that's usually with yourself. So I'm not trying to impose upon you that you have to do this, but normally people that go into the courtroom should have a better working idea of how that works. So we advocate the trial book, as you've seen a number of times today. The trial book is almost like a primer, and this happens to be the student edition, and it involves tear-out pages, so you can make mistakes and not have to ruin your trial book. But why it's important is it lays out every facet of the trial. So the first thing it does, well, obviously the index is there, but the first thing it does is lay out how much you know about your own case. So most people don't understand the difference between the case and what they want. So they're as likely to go in there and say, "Judge, somebody didn't keep their word with me and I want some revenge." So what it does is allow you to lay out in specific terms exactly what your opponent must do and exactly what you must do. And it includes such mundane things as discovery. Now, you've heard a lot of talk about discovery today, and admittedly I do it somewhat different than the trial book reflects. And some people are more resourceful than others, so you can make up your rules as you go. But for the most part, it starts with case analysis, and it provides a space for you to write down the facts. And although these are called lawsuits and not fact suits, they're based on facts bolted to the law. So if you haven't a clear understanding of exactly what the facts are, you may plead the wrong law, and as Michael pointed out, you lose. You'll have the right decision based on the wrong facts. It goes through such mundane things as, what would you say, the proof that you intend on offering. Oh, you want me louder? Okay, the proof that you intend on offering. And it allows you a method of outline so that the facts that you're going to prove are supported. Now, they're supported by either witnesses or actual evidence. It allows you to make a form and to tie the form to the witness, to tie the witness to the evidence, and to put it in its proper sequence. So a lot of times when you have the witness testify or when you introduce the fact or the evidence is very relevant to how believable it is. So in many cases, especially in the civil area with pro se litigants in particular, no one seems to know how this is supposed to work. There appears to be a rumor afloat in this area, by the way, of bringing me back out here to teach just exactly this, so we won't spend too much time with it. The next thing you'll have is the theories. So though you have the facts and though you have the evidence, there's an item called a legal theory. And the legal theory is the degrees of liability or the degrees of wrong involved. So if you're suing under 42 U.S.C. Section 1983, you have to allege certain aspects of that. And it's, as Michael laid it out, it's in the jurisdiction statement. But nonetheless, the theory is still should be committed to writing. If you can write it and convince yourself of it, it probably will be provable when you get to the law library, which is the next step, because then it's fact theories, not just legal theories. And following that are the alternatives. A lot of this will depend or be predicated on whether you're defending or prosecuting, by the way. But for case planning, in every event you need to do a certain amount of research. And I don't care if you're doing a traffic case, a parking case. The degree of what we say liability for losing may be less, but the procedure is exactly the same. So although many people disagree with me, I treat a traffic case as being every bit as important as a murder case, because it is. If you can defeat a traffic case, you probably could defeat a murder case. Conversely, how many traffic cases have you won? Very few people win traffic cases. And it's because there's what we say, a concept out there that everybody has to have a driver's license. Now, because it's on tape, I won't tell you that your children are supposed to be born with one sticking out their butthole, but if it weren't on tape, I would tell you such a thing, if everybody had to have a driver's license. On the other hand, it's reasonable to assume that your neighbors are trained differently. They're trained that if I have to obey the law, you have to obey the law. And in fact, the prosecutor will often point this out. We're all subject to the law. We all have to obey the same laws. Now, if you ask him a couple of questions, you could put him in error real quick, but we'll get into that a little bit later. When you're doing a case, as this thing outlines, along with your case planning, not only do you have to do legal research, but you have to gather your facts. And as mundane as most of this sounds, most people miss it. In other words, if you're saying that were injured by a police officer, it's merely an allegation. What are the facts available that would prove that? So what I normally do is with the police officer, because I believe in planning for a defined end. So for instance, let's assume a traffic stop. If the police officer is going to stop you, obviously he has your best interest at heart. Perhaps. I doubt it. So if he's going to stop you, you might as well start gathering evidence, because obviously he is. So your responses should be based on questions, not on answers. So you might consider asking the police officer, and again, you have to count the cost of this and judge accordingly, but you might consider asking the police officer whether or not he's investigating a crime. And if he isn't investigating a crime, are you the object of that investigation? If you are the object of that investigation, does he intend on punishing you in any manner if you fail to give evidence which he intends on using against you? Now, the elements of 42 U.S.C. Section 1983 are such that he must deny you a known civil right, or at least a right. The elements of 1985 are a conspiracy, so you might ask him if he would call in a witness, meaning a backup. By the way, he'll call a backup anyhow. But if you ask for a backup to support your contention that here he is on the highway eliciting information from you under threat, which he has informed you he intends on using against you in a criminal case. Now, because you are interested in gathering evidence for your case, you're not really concerned about what he's doing other than whether or not he'll admit it and whether or not he'll admit it in the presence of witnesses. The old law says at the mouth of 2 witnesses or at the mouth of 3 witnesses shall the matter be established. Strangely enough, it's much easier to establish fact matters if you have 2 witnesses. Now, if the policeman is willing to write a citation to support your case, why would you not want him to do it? So caution him to write legibly. These things are often difficult for the jury to read. And we most certainly want the jury able to understand who wrote this and why. Now, for the most part, I think the last count we were at 23, and I have been given 1 citation doing this, and we're currently litigated in Illinois. But nonetheless, usually the police officer wants no part of somebody that's so out to lunch and off the wall that he would attempt to gather information for his case based on the police officer's case. But in the event they are, it's very real, and as you saw Michael lay out the elements for a 42 suit, This is exactly what you need. You need time, place, who, and how. So he's laying out these elements for you. Now, if he intends on prosecuting you or punishing you for exercising your right to remain silent, can you be compelled now to present him with a driver's license to prove you don't have one? Because if you don't, he's going to charge you with failure to present a driver's license or display a driver's license. And of course, the opposite side of that is, what were the conditions whereon he thought you were engaged in an activity for which a license could be displayed? Because your next question is it not a felony to give false information or disinformation to a police officer? See, to falsely identify yourself to a police officer in some states is considered a crime. It may be in this state, but I don't know. And it's false because if you wrote to the legislature or to the Department of Transportation and solicited the information in the following manner, it would be, dear sir, I attend meetings of the people for the purpose of establishing our civil rights. I need a license from you to enable me to travel on my private property to do so. Do you think a license for that would be forthcoming? Yet the law says that the right of the people to peaceably assemble shall not be infringed. It is not the requirement to impose licensure on your attendance an infringement of the first. Now, can you be required to waive a right to assert a right? Can you be required to surrender your right or your liberty as a condition of attending the assemblies of the people or petitioning for redress of grievance at the courthouse? Gee, it's kind of interesting when you think about it. But back to our case analysis. All of the evidence that you are going to gather is best gathered early. As soon as they know they're going to be prosecuted, they're very reluctant to give information. In fact, you'll find when you prosecute a police officer that he won't talk to you anymore. Okay. He says that I've been advised by counsel to not give you that information. So you have to go to counsel. Suppose you could use that to your advantage. Okay, and you can, but it's part of what we teach. In any event, when you are done gathering your facts, you have to put it into a form called a pleading. And of course, the pleadings might cover it. I'm not going to cover that all. And then you'll need to know who your support staff is. One thing many people in this movement overlook is the fact that there are laws respecting the use of the courtrooms. And it appears that most people think that the rules for the courtroom are the rules of decorum laid out in the civil rules and the rules of criminal procedure. And I think Michael read to you at the outset that Rule 1 is that these rules govern proceedings in the civil courts. If you read the rules of criminal procedure, it says these rules govern criminal prosecutions in the courts of the United States, including misdemeanor, petty misdemeanor, felony, and gross misdemeanors in some state cases. You'll notice that they don't govern or regulate defenses. Now, they regulate lawyers, but they don't regulate defendants, which is kind of odd, or the accused. If you understand why they don't do it, it would make your life a little bit easier. Now, I've only pointed out for your edification, and I'm not suggesting that you do anything wrong, and I definitely don't proceed in court the way most people do. It didn't work for me consistently, and I felt very awkward. For instance, they would ask me if I was a defendant, and my response was naturally dishonest. So I would say, yes, I am. And then when I thought about it, I didn't know what a defendant looked like. I didn't know if they were different colored, if they were taller, fatter. I knew they usually got in trouble. I knew that defendants usually wound up in jail or fined heavily. I knew that they had to make appearances. I wondered why I was making these admissions. So I tried it once. And they asked me if I was the defendant. And I said, I did not accuse. And the place went bedlam. The question now is, what do you mean? I said, I'm sorry, my tongue doesn't work too well up here. But I didn't accuse. Does not the law require the accuser to accuse as opposed to the accused to recommend that he is in fact the one accused? Am I required to identify who the accuser is, or is the accuser required to identify me? If I fail to accuse myself, what's the penalty? They get to be interesting questions, by the way. And you'll also incur the wrath of every prosecutor and every judge. So beware. Nonetheless, it's more than I can bear, and I don't mind a little bit of wrath once in a while. It became obvious that if I couldn't honestly identify myself as a defendant, then I was missing some information. That I had come to know what wasn't so. That I actually believed that a document could make me a defendant. That the mere instance of a police officer issuing a citation would cause me to represent myself as a defendant by promise to appear or acceptance. Now, if you understand how the law works, in America in particular, and the states individually, there's what's called a separation of powers, which means that the legislature legislates, the executive executes legislation, and the judiciary determines whether or not both are effective as to that particular application. So beware when you say a law is unconstitutional. It would be perhaps best said unconstitutional in this application. Nonetheless, every time you're required to make a statement in a court, it's going to be used against you. Every time the police officer stops you, that information is going to be used against you. So one of my earlier instructors, a fellow by the name of George Gordon, taught me a memorable lesson. And he said there's 3 main rules to quote-unquote pro se litigation. And they are: be quiet, don't say anything, and shut up. Right? Now, that doesn't mean you're not to involve yourself into this. It means that you're not to give information about you. So you can talk about anything except you. Now, the best way to do that is to ask questions. So when the police officer approaches the window, you can ask him who he's looking for. If he's not looking for anybody in particular, how can I help you? Right. Now, the other side of that is don't get smart with me. And of course, you should not. Cast in your pearls before swine is a penalty for it, and you'll soon see why. In any event, as this thing unfolds and you see that the verbiage being used against you to represent yourself in the courtroom as a defendant or to appear pro se is very deceptive. If you say you represent yourself, then who's going to be left unrepresented? If the representative has to be empowered by the representer. Consider the state is represented by the prosecutor, probably because the state's too ugly to appear on its own. But if you agree to be represented by an attorney, you've waived not only a valuable asset, but a right. In some states, it's written right into the Constitution that you can appear by attorney or in person. But did you notice it's appear? Appearances are deceptive. Now, most people aren't deceived by it, they just aren't aware of it. So the ignorant are truly unaware of what they don't know. If you agree to represent yourself, you've said in effect, I'm attorney for myself. See, you notice the representatives never go to jail? So while you appeared for yourself, which is to stand in that place, meaning attorney means one who stands in the place of another. So your act as your own attorney. The law is quite specific. It says in all criminal prosecutions, the accused shall enjoy the right to the assistance of counsel. If you broke off the word assistance, you would have nothing, because it doesn't say anything about appearances. If you struck the word counsel, it would be absolutely a complete statement. In all criminal prosecutions, the accused shall enjoy assistance in his defense. I don't see any problem with that. The Bar Association has done something very subtle. Now remember, the Bar Association absolutely controls this country. You don't see any legislatures without a judiciary committee composed of lawyers. Almost all laws in this country are drafted by the lawyers for the publishing services, West Publishing being the largest one. And it has, I don't know, I think it's about 70 lawyers on staff that do nothing but formulate verbiage for statutes. It's incredible. And you'll notice the sameness across the country in the statutes. It used to be, before they got their hooks into it in the 1800s and early 1900s, that there was quite a variety of terminology. Now it's almost like a cookie cutter, which makes it more and more difficult, if you will, for defendants. The defense always loses, by the way. Otherwise, you couldn't get into the appeals court. All of those losses are represented by cases. And so it doesn't matter if the United States appeals or if the government appeals or if the state appeals, it's because of a procedural defect. But because in a trial by jury, there's no possibility of them appealing your non-conviction. Now they've set it up so that it's very much in the nature of a card game. If I hold all the cards and I determine who can deal, I can tell you the outcome of that game. I just choose the dealer and train him. Nonetheless, if you walk in there and you say you're representing yourself, or you get into this argument about counsel, you're going to lose. There is so much case law out there on counsel, it fills volumes. On the other hand, ineffective assistance of counsel has been beaten and bantered about to where the case law now virtually reads that if you had a licensed lawyer representing you, you had adequate representation. And we're seeing it everywhere. The upshot of that is when we started doing the study, when I started saying that I didn't know I was a defendant or how I could establish it, how would I stand in front of the Creator and describe to him what I looked like before I became a defendant and what I looked like afterwards? What was the change? In any event, counsel came about the same way. Representation and appearances are deceiving. What would happen if you didn't do that and that you insisted that you have assistance? And of course, I prefer her for my assistance. She trusts me, and I trust her. She knows me. She knows how I think. She's more articulate than I am in forming questions. By the time you got to that point, they'd say, well, we can't let an unlicensed lawyer speak for you in here. So now you can illustrate this or discover it by asking, oh, you thought I was a licensed lawyer? Because you can speak with attorney or by yourself or a peer, but you can't use assistance inappropriate to the bar system. And the bar system controls it. They have a real art form going on here. Peter was pointing out the similarity between the high priest in his altar, or I should say the judge in his robe, and the way the bench is set up, the communion rail. But did you know that the parties move with prayers for relief? Kind of interesting. And they do it in this ecclesiastical language. Okay, so the prayers for relief are brought by intercessors called lawyers. See? Kind of odd, and it's because you're too dumb. You don't understand the language, so you need assistance, or I should say representation. All of that is built into this entire system. And what I try to do in the classes where we try to get the average individual to be able to walk, talk, and chew gum in the courtroom is to take the myth away so that you can see how to use it. Because though you understand, your opponent won't. And I think as Peggy pointed out, there is an aversion to pro ses who walk into the courtroom. I mean, they think you're the scum of the earth. And that's okay, because winning has nothing to do with the facts. It has to do with control of this trial program. And although Michael does it one way, Peggy does it another way, my strategy is to create havoc. Well, I'm not a nice guy when it comes to that. Now, each method has its, what we say, blessings. In the normal sense, if you followed what Michael went, you can't tell Michael's writings from that of a brilliant lawyer. You really can. I've seen lawyers that looked at his pleadings, because I brought them to him, and they were flabbergasted. But that notwithstanding, they're flabbergasted when I do it too, and mine looks like trash by comparison to Michael's, except mine doesn't say the same thing. Say, well, the legal system is brought up on these ecclesiastical terms, and I'm not a Latin scholar or anything, and I don't speak good French or good legal French, whatever you want to call it. I usually use the mundane, down-to-earth common sense with a twist here and there. So my pleading would be far different. For instance, if I'm prosecuting a case, it would be Dwayne Rogers on behalf of We the People, or We the People, by the hand of Dwayne Rogers, in the exercise of accountability, make known the following. Now, because I'm a quote-unquote religious objector, I can't do an oath for fear of being a hypocrite. Now, I swear like a damn preacher, so don't get me wrong, but I don't do oaths. The way that it's best handled now, it's not for everybody. So once you take up this, if you will, plow, you can't back away from it. You can't do oaths one day and not do them the next. The concept, though, is out of the scripture. If it says swear not at all, swear is etymologically the same word as to sevens oneself. So to say 7 times is to swear. You can't have an oath without a swearing. So oaths result from a swearing. Now, I did this to a judge. He said, well, if you don't do oaths, would you do an affirmation? I said, well, let me see how that would go. You're saying that an oath and an affirmation are different? He said, yeah, affirmations are for people who have religious objections to doing oaths. So I could swear an oath. Is that your position? He said, yes, you could. I said, could I affirm an oath? He said, yes, you could. I said, don't they both result in an oath? It's not pretty hard. Now, as different as that is, the opposites will often startle you. So the scripture lays it out that anything more than yes or no comes from evil. And because most people can't articulate well or reason well, what I instruct is if you think it's more than yes or no, when you don't know, ask. So for instance, I had a judge just ask me if I would promise. And I said, is a promise more than yes or no? Okay. So you answer not a fool according to his inquiry. But you answer a fool according to his inquiry. But don't be fooled. Okay. The idea of the scripture being the law is best, what would say, brought to their attention by your fruit. If you can swear not at all, then it's not even a question of whether or not you'll take an oath or an affirmation. It's your practice. So when I get to the end of a document, it usually contains the names of the witnesses right in it, which now makes it at the mouth of 2 or at the mouth of 3, you'll have to overcome it. In other words, the document exists prima facie, on its face is correct, unless you have a witness to the contrary. Now, that's done by incorporation, and all I do is, we the people of the state of North Carolina, by the hands of Dwayne Rogers, in the exercise of accountability, make known the following. You go through whatever you want to direct their attention to. When you get to the end, you say that this document is to be construed as at the mouth of 2 witnesses or at the mouth of 3 witnesses shall the matter be established. And in the presence of Peter, John, and Michael Brown, this document was formed by the hand of Dwayne Rogers for the purpose elucidated, and further writer says not. Now, so far, they have not brought my documents. Inquiry. But you answer a fool according to his inquiry. But don't be fooled. Right. The idea of the scripture being the law is best, what would say, brought to their attention by your fruit. If you can swear not at all, then it's not even a question of whether or not you'll take an oath or an affirmation. It's your practice. So when I get to the end of a document, it usually contains the names of the witnesses right in it, which now makes it at the mouth of 2 or at the mouth of 3, you'll have to overcome it. In other words, the document exists prima facie, on its face is correct, unless you have a witness to the contrary. Now, that's done by incorporation, and all I do is, be the people of the state of North Carolina, by the hands of Dwayne Rogers, in the exercise of accountability, make known the following. You go through whatever you want to direct their attention to. When you get to the end, you say that this document is to be construed as at the mouth of 2 witnesses or at the mouth of 3 witnesses shall the matter be established. And in the presence of Peter John and Michael Brown, this document was formed by the hand of Dwayne Rogers for the purpose elucidated, and further writer says not. Now, so far, they have not brought my documents. In fact, the only time it's happened that they didn't want to take it, the prosecutor had initially sent it back, and the judge says, no, let me see that. And he took it, and he looked at it, and he said, no, we'll take that. So there's no judicial determination, but so far, nobody's managed to dump it. And it wouldn't matter. The whole idea is to, what we say, bear the fruit. In other words, James says, be therefore doers of the law, not merely hearers or sayers. So, while Peter calls this the spiritual side of the law, it's actually a corruption of whatever they're doing. You're literally giving them back all that they want and more. So it's, in effect, how can I help you become more corrupt? When you get to this, so the support staff that you need is based on that. Now you get to a systemized approach, and that literally means something like this. And it takes about three ring binders to build the average traffic case file. And it's because you're making copies of all of this. And at the end of each chapter is kind of a neat little deal. It says how to avoid, what would you say, appeal. Let me find one here. It says avoiding mistrials and reversals. Now, to most people, if you're the prosecutor, you want to avoid that. If you're the plaintiff, you want to avoid that. If you're the defendant, you want to cause that. Right? And it's a matter of reason. It's very easy to be convicted of a traffic offense. For instance, if you were charged with driving without a license, how do you prove a negative? And the illusion is that somehow it's the state's burden, and they'll even instruct the jury that you're to be presumed innocent. But see, innocent is not the same as ignorant. So your 2-year-old child could be charged with driving without a license, and based on the facts, be established as guilty. It's real easy to do. You're charged with speeding. How difficult is it for a police officer with a skilled prosecutor testifying as to all of his training and all of his expertise and the high technology equipment and all of the rest of it to establish whether or not the police officer was trained, in fact, to look at a radar unit and get a reading of it? Okay? I mean, I laugh at this because it's preposterous on its face. It's a jurisdictional argument, usually. Or you can, the one we just did in Illinois, they were so outraged because I kept asking questions. Once you understand how the question thing works, it's based on a foundation. So you can't ask the question that you don't lay foundation for, you can't ask a question that's immaterial to the cause, and you can't ask a question that is, what we say, conclusionary. And there's like 33 times 33 objections. So within every objection, there's a set of concepts that would allow certain differences there. So for instance, the exclusionary rule, or they exclude evidence that's been wrongfully brought in. I think there's 70 separate conditions under which evidence illegally seized can be brought in. So much for the rules. On the other hand, if you know how to ask questions, the rules now take on a new dimension. Okay? So you can go back to the separation of powers and ask the police officer, remember, whether or not he's a member of the legislative branch of government. Because otherwise you're going to be found doing an accusatory thing. In other words, you're going to say, you're a police officer and you can't issue a ticket because you're a member of the executive branch of government. But the foundation laid is out of his own mouth. He's certified, he's trained, he acknowledges the training, and all you have to do is expand on it. Now, additionally, we encourage people, especially in the criminal cases, to call as your witnesses all of the opponent's witnesses. And there's a good reason for it, but nonetheless, if you've got a prosecutor who doesn't lay proper foundation, you perhaps would be denied some of these questions. And because the questions are necessary to display your point without you testifying. Remember, people like me are not allowed to testify. I don't do oaths. I don't do affirmations, which raises another constitutional question, but for the most part, for our illustration, if you can ask the police officer the right questions, he'll testify on your behalf. So you can ask such things as, did I inform you that I was involved in a regulated activity? Okay, most people would say, was I driving a truck? Well, the answer is no, and now what are you going to do? So, to your information and belief. So that you can postulate these questions in any number of different ways, and the more you do it, the more skill you develop at it. In this Illinois case, they were angry because it didn't seem to matter what they objected to. I just reformulate the question. In other words, you can add information to it and, in effect, testify on behalf of the police officer. For instance, is it your position that you're a bad police officer? Well, most people would think of it the other way. Are you a good police officer? What you're going to do is propound it in the positive or propound it in the negative, and it causes a different effect. Consider what the jury hears is what you're after, or what the judge hears, or what the appellate court hears, because it really matters little at this level. You want to set for appeal. So the more objections you can get to your form of questions, the better your chances are of having it overturned. And when we come back, we're going to go into a little bit more detail, and we're going to take some questions off the floor. And I think...
Mr. Rogers is available as a consultant on a fee basis, and his seminars called the False Witness. $47.10. $81 is the voice. 0682 is the fax. We're going to take a short break, and we hope you do too.
And that means I'm supposed to talk again, right? Now, I've been asked to speak up. Is there anybody else in here that can't hear me? I'm usually... who said that? Huh? One of the things that people neglect is definitions. And the courtrooms are full of words that are curiously not found on the street. And anytime you run across the word that you think you know, look it up once and you may be bemused to find you didn't know. A case in point involves this oath issue, and I had gone over it briefly before, but if you've ever had the opportunity to get into the law library, you'll find an old set of books called Bouvier's Law Dictionary. Ambassador Fox here sells this one, and this happens to be the one I use a lot of. Rather unique definitions that you don't necessarily find in other dictionaries, and there are other dictionaries too that are equally good, but Bouvier's happens to be my particular favorite. For instance, an oath is defined as an outward pledge given by the person taking it that his attestation or promise, so that means a promise is computed or counted to be an oath, as is an attestation. That an outward pledge given by the person taking it that his attestation or promise is made under an immediate sense of his responsibility to God. Now, for those so-called religious objectors, there might be some question about which God in this particular. The term has been variously defined as a solemn invocation of the vengeance of the deity upon the witness if he does not declare the whole truth so far as he knows it. It's similar to putting God to work for you. So you're saying, come on down here, God, and let's kick some butt if I'm wrong, but you got to do it for me. Right? Most people wouldn't dream of putting God to work for them. But in this case, that's what it would sound like. So help me God. A religious asseveration. So an asseveration then, if you find it under oath, a religious asseveration by which a person renounces the mercy and imprecates the vengeance of heaven if he does not speak the truth. Gee, it gets pretty obvious. So here's a asseveration determined to be an oath. Now I know there's, I think, a gentleman from Wyoming was the first guy you heard use the term asseveration. Asseveration is usually defined as a binding of the conscience, as opposed to a word or something like that. But in any event, these are just gold mines. And there's a lot of good things as well as a lot of bad things. And you have to know yourself before any of this works, by the way. One of the things that came to mind when we're talking about Bouvier's Law Dictionary is it has a great definition for something that everybody accepts as being part of their life every day. And they're the corporations, whether they be municipal or private. They are not found in the ancient law. So the Creator didn't make corporations. They're a recent innovation. In fact, they were invented for a peculiar reason. But nonetheless, in our law, they're termed fictions of law. Now, a fiction of law, well, I'll just read what Bouvier had to say about it. Fiction, the legal assumption that something which is or may be false is true. I mean, that's the premise for this whole thing. Now, how could you have a legal assumption that something which may be false or is false is true? Gee, that's kind of strange. The expedient of fictions is sometimes resorted to in law for the furtherance of justice. Love it. From a case called Cochrane Oil and Development Company versus Arnaudette, 199 U.S. 194, 26 Supreme Court 41 at page 50, or excuse me, page 50, and then 50 Law Edition, page 143. The lawmaking power has no need to resort to fictions, so the legislature doesn't need to resort to fictions. It may establish its rules with simple reference to the truth, but the courts, which are confined to the administration of existing rules and which lack the power to change those rules even in hard cases, have frequently avoided the injustice that their application to the actual facts might cause by assuming, in behalf of justice, that the actual facts are different from what they really are. Thus, in English law, where the administration of criminal justice is by prosecution at the suit of the Crown, and in the United States by the suit of the government, the courts, rather than disregard the rules which all other parties stand in respect to their neglect to appear and prosecute their suits, adopt the fiction that the king is legally ubiquitous. The United States is everywhere, that its representatives are, so that he can never be non-suited. The employment of fictions is a singular illustration of the justice of the common law, which did not hesitate to conceal or affect to conceal the fact that a rule of law has undergone alteration, its letter remaining unchanged. Gee, and this out of an old book. Now, the idea, though, is that if you know what a fiction of law is, or what a legal fiction is, why would you subscribe to it? How much good does it do you? And what is the benefit of accepting it? See, if everybody has to appear and defend or prosecute their suits on their own, how is it that some people are given this immunity? They never have to appear. Well, in American jurisprudence, it's written that a corporation may appear by attorney or representative. I submit that they couldn't appear otherwise because they don't live anywhere. You couldn't serve process. You couldn't draw blood. In fact, I had a little saying that always gets me in trouble. I always tell people, if it doesn't feed, if it don't bleed, if it don't breed, don't talk to me about it. In any event, back to the story here. As you go into the courtrooms, you'll find there's a rather large amount of anomalies that aren't what they appear to be. One is the counsel thing. The other is trial by jury. The law says it in a couple places, and trial by impartial jury appears to be impossible because partiality is necessary. So how could you have an impartial jury? They're going to be partial to one side or the other, even if they don't know it. In any event, one of the things that you have to do besides putting these three-ring binders together and understanding how the trial system works is to get a method of illustrating the evidence. So sometimes evidence is going to be testimonial, sometimes it's going to be factual, and sometimes it's going to be actual. And sometimes it'll be presented in pictures or charts or of that nature. Putting that together and keeping it listed so it's introduced at the proper time is sometimes difficult. When you have, trial memos is another issue that comes up. Memos often are used to accompany motions, but there are other memos that are sometimes required to the court. They're going to want to know the status of the trial, so you'll hear the term status conference. Another one you'll hear is trial briefs, and they are actually close to the same function. And then it asks you, and this book is very detailed, so I don't want to go through all of them and waste all your time. One of them is preparation of witnesses. So if you're going to be the witness, who's going to prepare you? And if you're not going to be the witness, who is going to prepare the witnesses? And when the prosecutor prepares his witness, what does he do? So how do you prepare a witness? And it's something that we get involved in rather extensively. To current date, I think we finally lost somebody, but to current date, we had over 300 preparations for depositions, trials, grand jury appearances, etc., and we never lost anybody. I think that may be about to fall, but who knows? 1 out of 300 isn't bad. It is for him, by the way. Okay, the other thing is preparation for direct and cross-examination. So while you're preparing your witnesses, you have to understand that your opponent is going to be preparing his witnesses, and you should have some outline of what his anticipated testimony is. So normally speaking, when they give you discovery, they'll give you a list of their witnesses and of their evidence and their anticipated use. That is part of discovery. Another thing you want to be careful of is, and this is just a caution here, is witness integrity. One of the things that you'll find is that most people are liars. In fact, I'm noted for telling a federal district court judge that I was a compulsive pathological liar. And I don't know if I got him to believe me or not, but nonetheless, he threw me in jail for it. So sometimes if the witness's integrity isn't there, his testimony can hurt you more than help you. Now, with a police officer, you can structure your anticipated cross-examination around his anticipated testimony. And the one thing they'll all do is either uniformly raise their right hand and swear to tell the truth. And if you could destroy that truth somehow, you would destroy his integrity, or at least attach some significance to his testimony that wasn't there before. One of the ways that we do that is to prepare a series of questions. Now, one of the things that police officers do when they issue citations is they normally sign the citation under the statute, which provides that it's to be accepted as a complaint and summons, or on the face of the document itself, it'll say that I certify or I testify under the penalties of perjury or some such statement that the form and the contents are true and correct. And then the form itself will say summons and complaint or citation or whatever. The law for separation of powers provides that the members of one branch of government cannot lawfully exercise any of the powers properly delegated and belonging to another branch of government. The question is then, who issues judicial process, such as summonses? Now, when you issue a summons for a witness to attend, it has to be signed by the clerk of court. How is it that this individual is issuing summonses as a member of the judiciary? Now, he may or may not recognize that, and most judges are totally naive, but we've had more than one say you're exactly correct. What do you want to do about it? Say, because the truth is, you still were served, whether or not it's valid. Now, you can do a couple of things about it, by the way. You can move to dismiss for prosecutorial misconduct or improper process or any number of things that you want to do to follow through, but the idea is to challenge his credibility. Now, he'll always say that he'll swear to tell the truth, then you'll ask him if he, in fact, has ever violated his oath of office. Now, usually, because that's too far a reach, you need to narrow the scope or you're going to get an objection. But if it's not objected to, see how he answers. If it's objected to, rephrase the question. Did you violate any of the terms of your office in this particular instance when you issued this citation? Or you can narrow it down even further. But knowing how to ask the questions is the key. If he says he issued this process and the question is struck, you can still prove the point, because no member of the judiciary countersigned this document, and yet you were caused to come into court. Now, it may only be, quote unquote, only a violation of the separation of powers, but what purpose is there to have a constitutional statement or a constitutional prohibition if it's not to be obeyed? And this raises some interesting questions. And we've had cases in which the citation was summarily dropped rather than hear that issue. On the other hand, in our state, they have room for what they call a long-form complaint. And for pleading purposes, because you don't want to make an appearance, or I should say you don't want to appear deceptive, you can also ask for a long-form complaint. Then you use the long-form complaint to illustrate the invalidity of the original. So here's prima facie proof that the first one was improper because they issued the second one. And the second one does not look like the first one. So one must have been wrong. Right? So there are many ways of establishing evidence or conditions for appeal. And remember, this is appeal orientated. This is designed to upset the apple cart so that no matter what happens to the load, it's going to be heads you win and tails they lose. Another thing that this book provides, now so far we haven't even got through the first chapter, and this thing is 11 chapters long. So it's very detailed and very specific, and it's a great tool. Anybody that's going to litigate would do themselves a disservice by not having one of these. Whether you want a court or jury trial is another issue that'll come up. Now, it's supposed to be under the Seventh Amendment that in any controversy wherein the value exceeds $20, you're entitled to a trial by jury. But that applies only under certain conditions, and those conditions should be named by you, which is too long to get into here. But in any event, considering settlement in civil cases and in criminal cases, plea bargains, but in civil cases, oftentimes people try to avoid going to court, so you can encourage settlement by doing your homework early. If you have a well-written complaint, as Michael pointed out, good cases don't go to court. Say they scare the bejesus out of your opponent, they don't want to go. The next thing is planning the case around the closing argument. So yeah, that's kind of interesting. Actually, when you do closing argument, you summed up your case. So if you'll sum up your case early, this early before trial, you'll know what you have to prove. Right? Now, I normally don't advocate you do an opening argument when the prosecution does theirs, because that which the jury heard last, they generally remember best. So if they hear your opening argument immediately after the prosecutor's opening argument, the odds are they won't remember yours as well as if you do it after the prosecution rests. Now, for people like me who don't take oaths, we're not allowed to testify, you can do a heck of a lot of testimony in an opening argument if you know how to postulate it. And all of the objections against that testimony you can short circuit. For instance, you can instruct the jury, if you will, by jury instructions, or you can do it by reasoning, arguments. The judge will tell them that the arguments of the prosecutor and of the attorneys is not admissible as evidence. Now, it'll seem strange, but if you said you represented yourself, then your argument is not to be accepted as testimonial either. So you don't want to represent yourself in that particular, which sounds kind of odd, but like I said, it's part of the training program. You can understand it more when you get into it. If you're in the opening argument, you pointed out that the judge was going to tell the jury to disregard anything you said and how preposterous you thought that was. It's permissible and it may get objected to, but you'll find that they think of you as a prophet when they find the judge telling them you're to disregard these arguments. And if you can point out to them that you're not going to be allowed to testify as a witness in your own defense because you have a political or a religious aversion to oaths, and that for that reason they're not going to hear any defense testimony at this time. And it's not because you don't want to give them information, and it isn't because you wouldn't be willing to give them all of the information you had. It's because these people want you to perform a religious function as a condition of believing you, thereby depriving the jury of their right to hear the whole truth. Right? Now, a lot of this will sound like so much gobbledygook at the get-go, but if you go to court and if you'll acquaint yourself with what happens in there, particularly if you guys are attending court along with each other, you'll see almost everything that I've said come to pass, one way or another. Now, if you're willing to take that laying down, then stay out of the courtrooms. If you think you can win at trial, stay out of the courtrooms. If you think you can't win at appeal, stay out of the courtrooms. But if you think that if you do everything necessary to win, you will, these people don't have a chance. The trial book is a great tool for this, and I don't want to spend too much more time on it because we have a couple other things to get into. But to give you just an idea, it starts with the Chapter 1. You just heard some of the outline for it. Chapter 2 is trial rules in motion. And every motion is a mini trial. So while most people write motions off the back of their scratch paper and don't do the research necessary to support it by oral argument, they are in effect mini trials. And many cases are won at motion hearings. Now, I have a particular aversion to legalese, so I rarely use the term motion. I usually use the term either disagreement. In other words, I don't do objections, I do disagreements, and I use the term I direct you to do this or I direct you to do that, which causes some consternation, and it's deliberate. And I wouldn't ask you to do, something you don't comprehend. My purpose for doing it is a deliberate one, and it's to set up an issue. In other words, I'm different. I'm not trying to mimic a lawyer. I'm not qualified to be a lawyer. And I don't want to be qualified to be a lawyer. But I do have access to the courts in this country, and I'm going to do it this way. Now, you can imitate every other lawyer, and some of them are fantastic. And there are some pro se's out there that are fantastic. This happens to be a particular peculiarity of my own. And I feel, I would say, dishonest walking up to the judge and say, I motion the court to do this. Nah, I direct you to do this. And if you're not going to do it, we're going to argue about it. I'm going to write a complaint. It's called judicial misconduct. On the other hand, if it's not founded on fact or reason, and you tell me it isn't, then you don't have to worry about that. But I'm not going to sit there and make all sorts of silly, what we say, statements about notions that I don't understand. Now, not everybody thinks that way, and it's not a charge against anybody because they don't. If we were all the same, we'd look like clones, and it wouldn't be any fun anyhow. Again, at the end of every chapter, they go through how to avoid mistrials and reversals, which is where we left off at last hour. And again, my purpose is to lay the foundation for appeal, or reversal, if you will. And it's caused by, generally speaking, 5 to 6 procedural errors and or 1 rights violation. Will get you into the appellate court. Now, not everybody recognizes when the procedures have been violated, and not everybody recognizes when their rights have been trampled on. Most of us just feel that something's wrong. So what we say, the getting goes along with it. The more information you have, the easier it is to detect their failings. The neat thing is because this is so well outlined, you can almost infallibly detect an error. But it will take you a couple times through it, and it's the reason we were advocating classes. If you were having a moot court here, what would happen is as you came in the door, you'd draw a number, and the numbers are randomly assigned to a position. So one day you might be the judge, the next day a juror, the next day a witness, the next day a prosecutor, the next day a victim. It don't matter, but the more, what we say, roles that you play, the broader your understanding is. Now, we used to do this back in Minnesota. We used to put 80 people twice a week in a county of less than 25,000. Right. So for a while there, we reigned supreme. And then, of course, they dissipate as interest wands. Actually, the courts quit prosecuting, so there's nothing for us to do. But if you can establish any conditions whereby you have a group meeting, and it's easier 2 nights a week because oftentimes it's disadvantageous to attend all meetings at all times. And generally, most people are cliquish or clannish anyhow, and certain groups work better together. The objective is to get as much experience as possible. And wear the robe. Look silly or stupid. Set it up so the bench is higher, and feel what it feels like to look down on somebody. And there's a power trip here, by the way. And once you understand that, and the judge, make the dumbest of you the judge, by the way, and you'll see that he ain't so dumb after all. He's watched a lot of Perry Mason. In any event, if you can see putting something like that together, I'd be pleased to come out and play with it for a while. Chapter 2, Trial Rules and Motions. And then Chapter 3, Discovery. Now, it's been covered quite readily. I think Pettigrew does a good job on discovery, although I'm the opposite. I usually rag everybody to death. I abuse the system more often than not, and it's because I like jerking lawyers around. Right. Now, I have also been sanctioned for it, so they're warning to the wise that if you play this game, you'd better be prepared to take the punishment that comes with it. My luck has been I haven't run across any real smart lawyers, that knew that the discovery was being abused. And I have run across a few judges who understood it, but extended full latitude because I was a quote-unquote pro se. So it works in a lot of different ways in a lot of different areas. In Alaska, they bent over backwards for me. They could not do enough to accomplish me. And I was downright gross. I was making them jump through hoops and then, crap on the other side and give me the right color. And they put up with it. But some jurisdictions won't tolerate it at all.